Indian polity. In political terms, a constitution comprises the basic principles of the political system under which the people of a state are to be governed. It determines such matters as the composition, powers, and procedure of the legislature, executive, and judiciary, the appointment of officers, and the structure of offices which authorize, express, and mediate the exercise of power. In more general terms, a constitution consists of a set of rights, powers, and procedures that regulate the relationships between public authorities in any state and between the public authorities and individual citizens. Most countries have a written constitution or basic document which defines these relationships. The United Kingdom and Israel are, however, notable examples of countries without such a constitutional code. But all written constitutions have to be supplemented in practice from other sources. The words in any document need to be interpreted, and constitutional practice may well be amended over time. Thus, judicial decisions, custom, convention, and even authoritative textbooks may provide guidance and regulation, and may therefore be said to be a part of a country's constitution. It is possible to classify constitutions in a number of different ways, according to whether they are federal, like in Australia and USA, or unitary, like in the UK and France, according to whether they exhibit a separation of powers, as in the US, or a fusion of powers, as in the UK, or according to whether they employ some device for judicial review, as does the Federal Republic of Germany, or have a special procedure for repealing constitutional laws, as in Switzerland. It is possible to effect constitutional control in a number of ways, but the most common method in countries with a written constitution is to provide for constitutional court or council which is supposed to ensure that political institutions conform to constitutional norms. Constitutional law refers to that part of a legal system and legal tradition which is directly concerned with interpreting and applying the fundamental rules that define and delimit the powers, rights, and duties of governments and other organs of the state and citizens. It is not, of course, necessary to have a single written constitutional document in order to have a constitutional law. Indeed, any stable political system must have a set of basic and defining laws or conventions. In Britain, though there is neither a formal constitution nor a court specifically concerned with constitutional matters, there are clear legal rules and practices restricting the actions of political institutions, granting rights, and enforcing duties. Constitutional development in India. Modern democracy and constitutional government may be Western developments, but ancient India was not unfamiliar with republican institutions, democratic assemblies, panchayats, and safeguards that limit the power of the monarch and protected the public from abuse of authority. The concept of the supremacy of dharma was hardly different from the rule of law or limited government, points out Subhash C. Kashyap. However, it was under the British rule that the idea of a modern constitutional form of government developed. As the East India Company gradually changed from a mere trading group into a political authority on behalf of the British Crown, several charters and acts were passed by the British Parliament to regulate its conduct. Some of these are of significance from the point of view of India's constitutional history. A brief review of the various acts is given here. Regulating Act of 1773. This was the first step taken by the British government to control and regulate the affairs of the East India Company in India. It laid the foundations of central administration in the following three respects. 1. It designated the Governor of Bengal as the Governor-General of Bengal. The first such Governor-General was Lord Warren Hastings. 2. It subordinated the governors of Bombay and Madras to the Governor-General of Bengal. 3. It established Supreme Court at Calcutta as the highest court. Pitt's India Act of 1784. It placed the Indian affairs under direct control of the British government. For that purpose, it established a board of control representing the British cabinet over the Court of Directors, the governing body of the East India Company. Charter Act of 1833. It made the Governor-General of Bengal as the Governor-General of India. All civil and military powers were vested in him. Also, the government of Bombay and Madras were deprived of the legislative powers. This was the final step towards centralization in British India. The Act created, for the first time, the Government of India having authority over the entire territorial area possessed by the British in India. Moreover, the Act also ended the activities of the East India Company as a commercial body. Charter Act of 1853. This Act separated, for the first time, the legislative and executive functions of the Governor-General's Council. It also introduced a system of open competition as the basis of recruitment for civil servants of the company, and thus deprived the directors of their patronage power. Government of India Act of 1858. This Act transferred the government, territories and revenues of India from the East India Company to the British Crown. In other words, the rule of the company was replaced by the rule of the Crown in India. The powers of the British Crown were to be exercised by the Secretary of State for India. Thus, the Board of Control and Court of Directors were replaced by this new office. The Secretary of State was a member of the British Cabinet and was assisted by the Council of India having 15 members. He was vested with complete authority and control over Indian administration through Governor-General as his agent, and he was responsible ultimately to the British Parliament. Indian Councils Act of 1861. The provisions of this Act were: 1. It introduced for the first time the representative institutions in India. It thus provided that Governor-General's Executive Council should have some Indians as non-official members while transacting legislative business. 2. It initiated the process of decentralization by restoring the legislative powers to the Bombay and Madras presidencies. 3. It accorded the statutory recognition to the portfolio system. And 4. It empowered the Governor-General to frame rules for more convenient transaction of business in the Council. Indian Councils Act of 1892. It introduced the principle of election, but in an indirect manner. The Governor-General still had the power of nomination, even though the members were indirectly elected. Also, it enlarged the functions of Legislative Council and gave them the power of discussing the budget and addressing questions to the executive. Indian Councils Act of 1909. This act is also known as the Morley-Minto Reforms. Lord Morley was the then Secretary of State for India, and Lord Minto was the then Governor-General of India. It changed the name of the Central Legislative Council to Imperial Legislative Council and retained official majority in it. The provincial legislative councils, on the other hand, were allowed to have non-official majority. Apart from increasing the size of legislative councils, The Act also enlarged their deliberate functions. The Act also introduced a system of communal representation for Muslims by accepting the concept of separate electorate. Thus, this Act legalized communalism, and Lord Minto came to be known as the father of communal electorate. Government of India Act of 1919. This Act is also known as the Montagu-Chelmsford Reforms. Montagu was the then Secretary of State for India, and Lord Chelmsford was the then Governor General of India. It relaxed the central control over the provinces by demarcating and separating the central subjects from that of provincial subjects. The central and provincial legislatures were authorized to make laws on their respective list of subjects. The Act further divided the provincial subjects into two parts: transferred and reserved. The transferred subjects were to be administered by the governor with the aid of ministers responsible to the Legislative Council. The reserved subjects, on the other hand, were to be administered by the governor and his Executive Council without being responsible to the Legislative Council. This dual scheme of governance was known as diarchy. However, this experiment was largely unsuccessful. The Act introduced for the first time bicameralism and direct elections in the country. Thus, the Imperial Legislative Council was replaced by a bicameral legislature consisting of an upper house, the Council of State, and a lower house, the Legislative Assembly. The majority of members of both the houses were chosen by direct election. The Act also required that the 3 of the 6 members of the Governor-General's Council, other than the Commander-in-Chief, were to be Indian. Government of India Act 1935. The Act contemplated the establishment of an all-India federation in which governors' provinces and the chief commissioners' provinces and those Indian states which might exceed to be united were to be included. Diarchy rejected by the Simon Commission was provided for in the federal executive. Defense, external affairs, ecclesiastical affairs, and the administration of tribal areas were reserved in the hands of the Governor-General to be administered by him with the assistance of a maximum of 3 councillors, also to be appointed by him. The other federal subjects were to be administered by the Governor-General with the assistance and advice of a council of not more than 10 ministers to be chosen by him and to hold office during his pleasure, but to include representatives of Indian states and minorities and to be responsible to the federal legislature. The Governor-General had special responsibilities regarding certain specified subjects. Example, the prevention of any grave menace to the peace and tranquility of India. In respect of these subjects, he had a full freedom to accept or reject the advice of his ministers. The federal legislature was to have 2 chambers, the Council of State and the Federal Assembly. The Council of State was to be a permanent body with 1/3 of its membership being vacated and renewed triennially. It was to consist of 156 elected members of British India and not more than 104 from the Indian states. The Federal Assembly, whose duration was fixed for 5 years, was to consist of 250 representatives of British India and not more than 125 members from the Indian states. The British Indian members were to be elected not directly by the people, as was to be the case in regard to the Council of State, but indirectly by the members of the provincial legislative assemblies. There were to be 3 subject lists: the federal legislative list, the provincial legislative list, and the concurrent legislative list. Residuary legislative powers was subject to the discretion of the Governor-General. Even if a bill was passed by the federal legislature, the Governor-General could veto it, while even acts assented to by the Governor-General could be disallowed by the King in council. Diarchy in the provinces was replaced by autonomy, that is, distinction between reserved and transferred subjects was abolished, and full responsible government was established, subject to certain safeguards. The provinces were broadly freed from the superintendent's direction and control of the Government of India and the Secretary of State, except for specific purposes. They derived their power and authority directly from the British Crown. The governor was the head of the provincial executive and was expected to be guided by the advice of the popular ministers. However, the Act gave arbitrary powers to the governor to act in his discretion in certain matters. Provincial legislatures were further expanded. Bicameral legislatures were provided in the 6 provinces of Madras, Bombay, Bengal, United Provinces, Bihar, and Assam, with other 5 provinces retaining unicameral legislatures. The principles of communal electorates and weightage was further extended. The Act also provided for a federal court, which was established in 1937 with original and appellate powers to interpret the Constitution, but the Privy Council in London was to dominate this court. A federal bank, the Reserve Bank of India, was to be established. The Indian Council of the Secretary of State was abolished. The All India Federation, as visualized in the Act, never came into being because of the opposition from different parties of India. But the British government decided to introduce the provincial autonomy on April 1, 1937. The operative part of the Act of 1935 remained in force till August 15, 1947. Burma, now Myanmar, and Aden were separated from India, and 2 new provinces of Orissa and Sindh were created. The Simon Commission had promised dominion status in 1929, but the Act of 1935 did not confer it. The Act provided separate representation not only for the Muslims, but also for Sikhs, Europeans, Indian Christians, and Anglo-Indians. It thus placed severe obstructions in the way of developing national unity in the country. The hodgepodge of authoritarian and responsible government, as envisaged by the Act of 1935, fell far short of Indian national aspiration. The August Offer, 1940. On August 8, 1940, on the eve of the Battle of Britain, the Viceroy, Lord Linlithgow, made a fresh offer which promised the expansion of the Governor-General's Executive Council to include more Indians, the establishment of an advisory war council giving full weight to minority opinion, recognition of Indians' right to frame their own constitution, etc. In return, it was hoped that all parties and communities in India would cooperate in Britain's war efforts. The declaration marked an important advance over the existing state of things, as it recognized at least the natural and inherent right of the people of the country to determine the form of their future constitution and explicitly promised dominion status. However, the Congress rejected this offer, and Gandhi viewed it as having widened the gulf between nationalist India and British rulers. Cripp's Proposals, 1942. When the Japanese army began to knock at the doors of India after the fall of Singapore and Burma, the War Cabinet of Britain sent Sir Stafford Cripps with certain proposals to India on March 23, 1942, to elicit Indians' cooperation. The envoy promised fulfillment of past promises of self-government for Indian people. The scheme was that the future of India would be an Indian Union which would enjoy privileges of a dominion associated with the United Kingdom and other dominions owing allegiance to the British Crown. The main features of the proposal were: 1. Immediately upon the cessation of the war, steps should be taken to set up in India an elected body charged with the task of framing a new constitution for India. 2. Provision shall be made for the participation of Indian states in the constitution-making body. 3. The right of any province of British India to accept or not to accept the new constitution shall remain intact, and the dissenting province or state shall enter into a separate treaty with Britain. 4. Until the framing of the new constitution, His Majesty's government shall bear the responsibility for and retain the control and direction of the defense of India as part of their world war effort. But the task of organizing to the full the military, moral and material resources in India must be the responsibility of the Government of India with the cooperation of Indians. 5. Leaders of the principal sections of the Indian people were invited to take active and effective participation in the councils of their country, of the Commonwealth, and of the United Nations. These were all to be implemented after the successful end of the war. About the present, it was maintained that the existing constitution should continue. The position of the commander-in-chief was to retain as it was, which meant that he would be in sole charge of the defense of India. The Congress Working Committee opined that until the attainment of full responsibility to face the new problems and shoulder new burdens, it was not possible for the Indians to defend their country. It also thought that the Cripps proposal was fettered and circumscribed, and its certain provisions would gravely imperil the development of a free and united nation. The committee felt that even without curbing the authority of the commander-in-chief in conducting the war, defense should be under a popular member of the Executive Council. Finally, the Congress rejected the proposal and Gandhi called it a post-dated check. C.R. Formula, 1944. C.R. Rajgopalachari presented the C.R. Formula by which the Muslim League would support the Congress' demand for complete freedom. After the war, a plebiscite was proposed which would decide whether Muslim majority areas wanted to stay with the Indian Unions or not. But the plan was rejected. After Gandhi was released on May 5, 1944, on grounds of ill health, Wavell urged the need to set up a provincial political government at the centre based on a Congress-League coalition to ensure fuller Indian cooperation in war effort. As correspondence between Gandhi and Wavell quickly confirmed in July-August 1944, the Viceroy's offer fell far short of the minimum Congress demands of a genuine national government responsible to the Assembly, with only war operations temporarily under British control and an immediate and unambiguous promise of post-war independence. In July 1944, Gandhi proposed talks with Jinnah on the basis of the Rajgopalachari formula enunciated the previous April, but the Gandhi-Jinnah talks of September 1944 broke down. This did not, however, prevent growing cooperation between the League and Congress Central Assembly parties and the spread of rumors, later repudiated by Jinnah in January 1945, of an agreement between two assembly leaders, Bhulabhai Desai and Liaquat Ali Khan, by which the Congress and the League would form coalitions at the centre and in the provinces under the existing constitution as a wartime measure. Wavell Plan 1945. Under this plan, India was to be granted dominion status in the near future. The Indians would themselves draft the constitution. The Hindus and the Muslims would be equally represented besides the members of the scheduled caste and depressed classes. The position of the Secretary of State and the Viceroy would remain the same. The Viceroy would retain his power of veto, but these proposals were not to be applied to Indian states. The plan was rejected by the Muslim League. Lord Attlee's announcement, March 1946. The British Labour Party assumed power under Clement Attlee in 1945 and took keen interest in Indian affairs. On the basis of the first-hand report of the all-party parliamentary delegation he sent to India, Lord Attlee made a historic announcement in the House of Commons on March 15, 1946, on the future of India. He declared that as the tide of nationalism was surging ahead in India, it was in British interest to take positive action. He further said that the Cabinet mission was to visit India with the intention of helping it attain independence as speedily as possible, and that the Indians themselves were to decide what form of government would suit them. He rejected the veto power demanded by the Muslim League. Cabinet Mission Plan. March 1946, Lord Attlee sent a cabinet mission to India consisting of 3 cabinet ministers, namely Lord Pethick Lawrence, Sir Stafford Cripps, and Mr. A.V. Alexander. The object of the mission was to help India achieve its independence as early as possible and to set up a constituent assembly. The main recommendations of the mission were: 1. There should be a union of India embracing both British India and the states which should deal with foreign affairs, defence and communications with finances of its own. 2. Below the union government, there should be 3 group governments, each consisting of some provinces. 3. A constituent assembly should be set up to draw the future constitution of the country. And 4. Till the constitution was ready, a provincial government consisting of representatives of main political parties be set up at the centre. Indian Independence Act 1947. In July 1947, the British Parliament passed the Independence of India Act. According to the Act, power would be transferred from the British government to the Indians on August 15, 1947. 2 dominions, namely India and Pakistan, would be established. The legislatures of both the dominions would be empowered to pass any law. The Constituent Assembly of both the dominions would be free to decide whether their dominions would remain within the British Commonwealth of Nations or get out of it. Constituent Assembly. In the course of India's nationalist struggle for freedom, the demand for self-determination was emphasized by leaders from all sections. The resolution of the Indian National Congress meeting at Delhi in 1918 demanded the principle of self-determination to be applied to India. Gandhi said in 1922 that Swaraj must spring from the wishes of the people of India as expressed through their freely chosen representatives. Then a demand for a constituent assembly came in the Nehru Report of 1928. The Congress took up this demand as a part of its official policy in 1934, after refusing the Simon Commission recommendations of 1933 as not expressive of the will of the people. Jawaharlal Nehru declared that the Congress had proposed the Constitution of India must be framed without outside interference by a constituent assembly elected on the basis of adult franchise. And the working committee of the Congress reiterated the stand. At the Lucknow session of the Congress in 1936, it was declared, no constitution imposed by an outside authority and no constitution which curtails the sovereignty of the people would be acceptable to the Congress. The Cripps proposals of 1942, though rejected by the Congress as unacceptable, had one redeeming feature in that it conceded the request of Indians to frame their own constitution through a constituent assembly. On March 15, 1946, the cabinet mission came to India and in the course of its stay recommended the forming of the Constituent Assembly and an interim government. It was decided that the Constituent Assembly was to be elected indirectly by the provincial assemblies. According to the plan, the provinces of British India were grouped into three categories: A, B and C. Each province was allotted seats on the basis of the population in the ratio of 1 member for 1,000,000. The seats given to a province were decided among 3 communities on the basis of their number. The 3 communities being the Muslims, Sikhs and general, including Hindus and all others who were not Muslims and Sikhs. They were to be elected by the representatives of each community in their respective legislative assemblies by the method of proportional representation with single transferable vote. The Indian states were also to be given adequate representation, not exceeding 93 members. The elections to the Constituent Assembly were held in July 1946. The Indian National Congress won 202 out of 210 general seats, while the Muslim League got 73 out of 78 seats reserved for the Muslims. The Assembly was, however, not able to start its work immediately as Jinnah withdrew his acceptance and caused the Muslim League to boycott it. The Congress went ahead with its plan and appointed an expert committee to draft fundamental rights and arrange an early session of the Assembly. The party also accepted the Viceroy's invitation to form an interim government with Jawaharlal Nehru as Prime Minister. The League refused to join the government and continued to ignore the Assembly. A compromise between the League and the Congress could not be worked out. The League felt that if it pressed for a separate state for Muslims, it would ultimately get it. And the British government's periodic statements were ambiguous enough to encourage the League in thinking so. A statement issued by the British government on December 6, 1946, said that if the Constituent Assembly did not have representation from a large section of the Indian population, a constitution framed by such an assembly would not be forced on any unwilling part of the country. It appeared as if the British were admitting the possibility of more than one constituent assembly and state. Consequently, when the Constituent Assembly first met on December 9, 1946, the representatives of the Muslim League stayed away and only 211 members were at the meeting. Thus, about 1/4 of the nation was unrepresented. The League obviously felt that such a challenge to the legitimacy of the Assembly could not be ignored by the British. By the end of January 1947, it was clear that there was no possibility of the League's joining the Assembly. An uncompromising call for a separate Constituent Assembly for Pakistan had been called by Jinnah. The British government statement of February 20, 1947, stipulating a rigid deadline of June 3, 1948 for ending British rule in India, the June 3rd statement of the same year, and the ground situation in India made the partition of the country an almost foregone conclusion. On June 26, 1947, Lord Mountbatten, the Governor-General, announced the setting up of a separate Constituent Assembly for Pakistan. The Indian Independence Act 1947, passed with surprising speed, came into force on July 18, 1947. Composition. The Constituent Assembly was indirectly elected by the provincial assemblies, which themselves were elected on the basis of a limited franchise established by the Government of India Act 1935. The 1935 Act imposed qualifications on the basis of tax, property and education. This kept out more than 70% of the adult population from voting. The Constituent Assembly thus reflected the composition of the provincial assemblies, in which the Congress had a comfortable majority. Indeed, some members of the Constituent Assembly were not satisfied that the Assembly had a truly representative character and wanted a new Constituent Assembly to be convened on the basis of universal adult franchise. The Congress, however, was not in favor of this procedure, which it felt would prove slow and difficult to follow in conditions existing in the country at that time. The Congress, in its own way, had tried to broaden the representation in the Assembly to include different sections of population. Going beyond the Hindu, Sikh and Muslim groupings stipulated by the Cabinet Mission, the Congress Party sent directives to the provincial legislatures to include representatives of Anglo-Indians, Christians, Parsis, backward classes and women. Thus, all these sections found representation in the Constituent Assembly. Finally, when the elections were over, the Constituent Assembly consisted of leading figures of the Congress Party like Nehru, Patel, Pant, Rajendra Prasad, K.M. Munshi, C. Rajgopalachari, Abul Kalam Azad, leading statesmen, journalists and professors. Eminent lawyers like T.T. Krishnamachari, Aladi Krishnaswamy Iyer and Gopalaswamy Iyengar were active members of the Constituent Assembly. Learned public men like H.V. Kamath, H.N. Kunzru, K.T. Shah, K. Santhanam, B. Shivarao, Purushottam Das Tandon and Shyam Prasad Mukherjee were among those who made a lasting impression on deliberations of Constituent Assembly. Sarojini Naidu and Hansa Mehta were eminent women in the Assembly. Dr. Radhakrishnan was also a member. One man who guided the deliberations of the Constituent Assembly and left an indelible mark on the Indian Constituent Assembly was Dr. B.R. Ambedkar, not a congressman. After the partition, representatives of Bengal, Punjab, Sindh, Northwestern Frontier Province, Baluchistan, and the silent district of Assam were no longer to be members of the Constituent Assemblies of India. There was a fresh election in the new provinces of West Bengal and East Punjab. So, when the Constituent Assembly reassembled on October 31, 1947, there were 299 members, 229 from the provinces and 70 from the states. The composition of the Assembly reflected the different ideological views present in the country at the time. There were socialists, the Marxian, as well as the democratic variety. Both groups were opposed to private ownership of important means of production and wanted an egalitarian society. While the Marxian view wanted a revolutionary reconstruction, it was the more moderate group preferring peaceful parliamentary methods that held sway. Sardar Patel may be considered a leader of the rightist view supporting private enterprise. There were also the Gandhians proposing decentralized village government through panchayats. All these viewpoints influenced the constitution to an extent, but the dominant influence was that of the liberals and the democratic socialists. Work. When the Constituent Assembly first met on December 9, 1946, J.B. Kripalani, the then Congress President, proposed the name of Dr. Sachidanand Sinha, the oldest member of the Assembly, for the post of the Provincial President. Later, on December 11, Dr. Rajendra Prasad was elected as the President of the Constituent Assembly. The Constituent Assembly appointed several committees for framing the Constitution. Some of the important committees were 1. Union Powers Committee of 9 members, chaired by Jawaharlal Nehru. 2. The Committee on Fundamental Rights and Minorities of 54 members, chaired by Sardar Patel. 3. The Committee on Union Constitution of 15 members, with Jawaharlal Nehru as chairman. 4. The Provincial Constitution Committee of 25 members, chaired by Sardar Patel. 5. The Steering Committee of 3 members, chaired by K.M. Munshi. These committees submitted their reports between April and August 1947, and on the basis of these reports, Dr. B.N. Rao, the constitutional advisor, submitted a draft of the Constitution by the end of October 1947. This draft contained 240 clauses and 13 schedules. In order to consider this draft Constitution, a drafting committee under the chairmanship of Dr. B.R. Ambedkar was set up. The other members were Sir P. Krishnaswamy Iyer, N. Gopal Swamy Iyengar, K.M. Munshi, Syed Muhammad Sadullah, Sir B.L. Mitter, and D.P. Khaitan. After the first meeting, Sir B.L. Mitter ceased to be a member, and in his place, N. Madhav Rao was nominated. The drafting committee prepared the first draft of the Constitution. This was then circulated for the comments of jurists, lawyers, judges, and other public men. In the light of this criticism, the drafting committee prepared a second draft which consisted of 315 articles and 9 schedules. The second draft was placed before the Constituent Assembly on February 21, 1948. The draft was then considered clause by clause by the Assembly. The third reading commenced on November 14th and was finished on November 26, 1949. On this date, the Constitution received the signature of the President of the Assembly and was declared as passed. It had taken 2 years, 11 months, and 18 days to complete the task. Date of commencement. The provisions relating to citizenship, elections, provincial parliament, temporary and transitional provisions came into force with immediate effect, that is, November 26, 1949. The rest of the Constitution came into force on January 26, 1950, and it is this date that the Constitution refers to as the date of commencement. This date was chosen to perpetuate the memory of January 26, 1930, the day chosen by the Congress to celebrate Purna Swaraj Day. Preamble to Indian Constitution. The preamble to the Indian Constitution reads thus: We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Main features. According to M.R. Polland, the preamble is not a part of the Constitution, but it declares the sources, the ideals, and the political organization contained in the Constitution. It reveals the following features of the Indian Constitution. 1. Source of the Constitution. The words of the preamble, "We the people of India adopt, enact, and give to ourselves this Constitution," reveal that the Constitution of India has been framed in the name of the people of India, and the people are the source of all political sovereignty. Thus, the popular sovereignty is inherent in the Constitution. We will continue with the same topic in the next section. In the last section, we were discussing main features of the preamble. Second main feature, ideals and aims of the Constitution. According to the preamble, the aim of the Constitution is to ensure justice, liberty, equality, and fraternity. Equality and fraternity are the watchwords of the French Revolution. The word justice has been added to these words. It means that the aim of the state and government is to establish social, political, and economic justice. 3. Sovereign Democratic Republic. According to the preamble, the Constitution has established India as a sovereign democratic republic. These three words carry different and deep meanings. Sovereign means full internal as well as external authority. According to Cooley, the country having full internal and external power and recognizing no superior authority is sovereign. So, according to the preamble, India has full authority in all its internal and external matters and has not to bow to any outside superior power. The term democratic is comprehensive in nature. In a narrow political sense, it refers only to the form of government, a representative and responsible system. But in its broadest sense, it embraces, in addition to political democracy, social and economic democracy as well. For this purpose, the system of universal adult franchise has been introduced. Equal social, political, religious, and cultural rights have been allowed to the citizens of India. However, there is lack of economic equality. So, this factor has been incorporated in the directed principles. By proclaiming itself to be a republic, India has chosen the system of electing one of its citizens as its president, the head of the state, at regular intervals. The adjectives socialist and secular were inserted by 42nd Amendment Act as a populist measure. With the failure of socialist system, almost everywhere, and with the introduction of liberalization and privatization, the word socialist has become redundant. Secularism has never been defined, nor it is seriously practiced. So, it is at best a decorative term. 4. Objective of the Preamble. The Preamble defines the objectives of the Indian state. These objectives are a few in number. They are justice, liberty, equality, and fraternity. The essence of justice is the attainment of the common good. It embraces the entire social, economic, and political sphere of human activity. The term liberty is used in the preamble not merely in a negative, but in a positive sense as well. It signifies not only the absence of any arbitrary restraint on the freedom of individuals, but also the creation of conditions which provide the essential ingredients necessary for the fullest development of personality of the individual. Liberty and equality are complementary. It signifies equality of status, the status of free individuals, and equality of opportunity, which implies the availability of opportunity to everyone to develop his or her political capacities. Finally, the preamble emphasizes the objectivity of fraternity in order to ensure both the dignity of the individual and the unity of the nation. In a country like India, with many disruptive social forces, the unity of nation can be preserved only through a spirit of brotherhood that pervades the entire country among all its citizens, irrespective of their differences. Through the establishment of a new nation based upon justice, liberty, and equality, all must feel that they are the children of the same soil, of the same motherland, and members of the same fraternity. 5. Embodies the spirit of the Constitution. The preamble embodies the spirit of the Constitution, the determination of the Indian people to unite themselves in a common adventure of building up a new and independent nation which will ensure the triumph of justice, liberty, equality, and fraternity. 6. Constitutional significance of the preamble. From a strictly legal point of view, the importance of the preamble is limited. It cannot qualify the provisions of an enactment so long as the text is clear and unambiguous. But it embodies the spirit of the Constitution. The provisions of the Constitution have to be interpreted in the light of the promises made in the preamble. Salient features. The following are the salient features of the Constitution of India. 1. A written constitution. It is a written constitution. It was embodied in a document containing 395 articles and 8 schedules, which got enhanced to now 442 articles and 12 schedules. The Constitution contains not only broad principles but also details of the procedures. 2. Parliamentary government. The central and the state governments are basically parliamentary, like the British government. The head of the state is, no doubt, the president. But the real power resides within the cabinet, which is responsible to and removable by the parliament elected by the people. The position of the president or the governor is more or less a constitutional head, like that of the British Crown. There are, however, some features of the Constitution which are presidential in nature. First, the President has got the right to send messages to either House of Parliament. Secondly, the President has got the right to return non-money bills for reconsideration to the Parliament. Thirdly, the President can require the Prime Minister to submit for the consideration to Council of Ministers any matter on which a decision has been taken by a minister, but which has not been considered by the Council. However, These rights are not meant to be used under normal circumstances and hence do not prevent us from treating the Constitution, in a sense, parliamentary. 3. Secular state. The Constitution declares India to be a secular state. India has been declared secular state because of its policy of non-discrimination towards any religion. Secularism does not mean irreligion or indifference to religion. It merely denotes that so far as the state is concerned, it will not discriminate between one citizen and the other on grounds of religious beliefs, nor for that reason will the person belonging to any particular religious faith be entitled to any special rights or privileges. Subject to public order, morality or health, all persons are entitled to freedom of conscience, the right to freely profess and propagate any religion. Any Indian can occupy the highest office in India. There is no economic or political disability on account of religion. All religions are held equally in high esteem by the state and there is no state religion. 4. Fundamental rights. Fundamental rights are lifelines of democracy which cannot function in their absence. A comprehensive list of fundamental rights has been incorporated in the Constitution. To ensure their adequate enjoyment, a duty has been placed on the Supreme Court to see that these rights are not infringed. Presently, 6 fundamental rights are elaborated. They are right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. The right to property as fundamental right has been abolished by the 44th Constitutional Amendment in 1978. 5. Directive Principles of State Policy. The Constitution contains a comprehensive list of directive principles of state policy. The difference between the fundamental rights and the directive principles is that whereas the former are justiciable and enforceable through the court of law, the latter are not. Although the legal remedies to ensure their fulfillment are not available, yet their incorporation in the Constitution serves a useful purpose. Public opinion is the ultimate sanction behind them. All governments, present as well as future, irrespective of their party affiliations, are bound by them. The voters have got the right to judge the performance of a government with the yardstick of directive principles. The directive principles contain rights which, although valuable, are unattainable at the moment. 6. Combination of rigidity and flexibility. Our Constitution is a fine blend of rigidity and flexibility. For the amendment of strictly federal provisions, 2/3 majority of both houses of Parliament and ratification by at least half of the legislative assemblies of states are required. There are certain provisions which require for amendment only 2/3 majority in central legislature and no ratification by states is necessary. And lastly, there are some provisions which can be changed by a simple majority by the central legislature itself. It makes a part of the Constitution flexible. Our Constitution is also flexible in another sense. The President, by the use of his special powers, can transform the federal nature of the Constitution into a unitary one, giving the Union Executive a right to legislate on the entire state list. Even in normal times, the Union Legislature in some cases acquires the right to legislate on the state list temporarily. 7. Rule of law. Like Britain and USA, rule of law prevails in India also. It means that no person is above law. There is the same law for every person, irrespective of his caste, color, or sex. All are equal before law, and there are only one kind of courts to try them. 8. Judicial review. The doctrine of judicial review is implicit in the Indian Constitution. It prescribes limits to the power of legislation exercised by Parliament or state legislatures. However, the limits imposed are not of the same order as in USA. Here, a particular provision is subject to judicial review only if it is challenged in a court of law. Now we come to the topic of territory of the Union and reorganization of the states. The Union and its territory. Part 1 of the Constitution comprises 4 articles concerned with the territory of India. Article 1 stipulates that India, that is Bharat, shall be a union of states. The states and territories of India are to be specified in the first schedule. It is to be noted that the expression Union of India is not synonymous with territory of India. The Union includes only the states which are members of the federal system and share a distribution of powers with the Union, while territory of India includes the entire area over which sovereignty of India extends. If the federal system is the result of an agreement between its units, as in the case of USA, the agreement cannot be changed without the consent of all parties concerned. The national government of USA, which is described as an indestructible union of indestructible states, cannot thus alter state boundaries or form new states without the consent of states concerned. The Indian Federation was not the result of an agreement between independent states. So, there was no compulsion to maintain the initial organization of states as outlined in the Constitution, even when the interests of the nation demanded a change. The makers of the Indian Constitution, therefore, gave the Union Parliament the power to reorganize the states by a simple procedure. By the Indian Independence Act of 1947, the princely states were given the option of joining India or Pakistan or remaining independent. The integration of the princely states was managed well by Sardar Patel. It may be recalled that in the original constitution there were 4 categories of states and territories. Part A, which included 9 erstwhile provinces of British India. Part B, comprising the 5 princely states with legislatures. Part C, which included 5 centrally administered states. And Part D, mentioning the territory of Andaman and Nicobar Islands. But since the 7th Amendment Act of 1956, all the states except Jammu and Kashmir belong to one class, and all constitutional provisions relating to states apply to all of them in the same manner. However, it may be pointed out in this connection that certain special provisions applicable to Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Sikkim, Arunachal Pradesh, Mizoram, and Goa override the general provisions pertaining to the states as a class. As for the administration of certain scheduled areas and tribal areas within the states, provisions are specially listed in the 5th and 6th schedules. The Union territories are centrally administered according to provisions contained in Part 7 of the Constitution. They are governed by the President through an administrator appointed by him. At present, there are 28 states: Andhra Pradesh, Arunachal Pradesh, Assam, Bihar, Chhattisgarh, Goa, Gujarat, Haryana, Himachal Pradesh, Jammu and Kashmir, Jharkhand, Karnataka, Kerala, Madhya Pradesh, Maharashtra, Manipur, Meghalaya, Mizoram, Nagaland, Orissa, Punjab, Rajasthan, Sikkim, Tamil Nadu, Tripura, Uttarachal, Uttar Pradesh, and West Bengal. Since 1987, there are 7 union territories: Delhi, Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu, Pondicherry, and Chandigarh. Acquired territories. Besides the states and union territories, the territory of India includes any area acquired by India by purchase, treaty, cession, or conquest. These are to be administered by the Government of India, subject to legislation by Parliament. Thus, the French settlement of Pondicherry, which was ceded to India by the French government in 1954, was being administered as acquired territory till 1962, when it was constituted as a union territory. The Portuguese territories of Goa, Daman and Diu were acquired by annexation and administered as acquired territory till they were incorporated as union territory in 1961. Goa was given the status of a state in 1987. Sikkim was admitted as the full-fledged state of the Indian Union after a referendum in that country favoured its becoming a constituent unit of India. Reorganization of states. The grouping of the states at independence was done more on the basis of historical and political principles than social, cultural, or linguistic divisions. There was not enough time to undertake a proper reorganization of the units at the time of making the Constitution. Article 2 empowers Parliament to admit into the Union or establish new states on such terms and conditions as it thinks fit. By Article 3, Parliament has the power by law to form a new state from the territory of any state, or by uniting two or more states, increase or decrease the area of any state, or alter the boundaries or the name of any state. The only condition laid down for the making of such a law are 1. Such a bill must be introduced only on the recommendation of the President, and 2. Before recommending the bill, the President is to refer to it the concerned state legislature, which would express its views within a specified period. The President is not, however, bound by the views of state legislature. However, in the case of Jammu and Kashmir, the consent of the state legislature is required before a bill on such alterations is introduced in Parliament. Article 4 stipulates that any such law may be supplemental, incidental, or other consequential provisions and may amend the first and fourth schedules without going through the constitutional amendment process. A simple majority and ordinary legislature procedure is enough for Parliament to form new states or alter existing state boundaries. Thus, the will of the Union Executive and Legislature prevails in matters of altering or redistributing the territories of the units of federation. It may be noted that Article 4 does not apply to cession of territory to a foreign state. Any treaty or agreement involving ceding Indian territory to an outside authority requires a constitutional amendment to be implemented. States Reorganization Act. The government appointed a commission under S.K. Dhar to examine the feasibility of reorganization of states on a linguistic basis. The S.K. Dhar Commission preferred reorganization for administrative convenience rather than on linguistic basis. A Congress committee under Jawaharlal Nehru, Sardar Patel and Pattabhai Sitaramaiah, the JVP committee, too did not favor a linguistic base. However, in 1953, the first linguistic state came into being in Andhra Pradesh, created by separating the Telugu-speaking areas from the state of Madras. This followed a prolonged agitation and the death of Poti Sriramalu after a 56-day hunger strike. As there were several more demands for states on linguistic basis, a commission was set up under Justice F. Fazl Ali with H.N. Kunzru and K.M. Panikar as members to study its demand. It submitted its report in 1955. Its suggestions were accepted with modifications and the States Reorganization Act was passed in 1956. As a result, the four-fold distribution of states was replaced by 14 states: Andhra Pradesh, Assam, Bihar, Bombay, Jammu and Kashmir, Kerala, Madhya Pradesh, Madras, Mysore, Orissa, Punjab, Rajasthan, Uttar Pradesh and West Bengal, and 6 union territories: Andaman and Nicobar Islands, Delhi, Himachal Pradesh, Lakshadweep, Minicoy and Amandivi, Manipur and Tripura, vide the 7th Constitution Amendment. Agitation and violence again resulted in the bifurcation of the state of Bombay into 2 states, namely Maharashtra and Gujarat in 1960. Then, in 1963, the state of Nagaland was created, comprising a tribal area from the state of Assam. In 1966, the state of Punjab was reorganized on a linguistic basis on account of growing pressure over the creation of a Punjabi Suba as a result of the J.C. Shah Commission report. The Punjabi-speaking areas were constituted into the state of Punjab, while the predominantly Hindi-speaking areas were constituted as the new state of Haryana, and the hill areas were merged with the contiguous union territory of Himachal Pradesh. Chandigarh became a union territory, serving as the common capital of the 2 states. Meghalaya, which had been created as an autonomous sub-state within the state of Assam, was made a state in 1971. Himachal Pradesh was upgraded into a state in 1971. In 1972, Manipur and Tripura were elevated to statehood. In 1975, Sikkim was admitted as the 22nd state of India. Mizoram, Arunachal Pradesh and Goa became states in 1987. India's political map was redrawn again in late July, early August 2000, when both houses of parliament passed the Madhya Pradesh Reorganization Bill 2000, the Uttar Pradesh Reorganization Bill 2000 and the Bihar Reorganization Bill 2000 for the creation of Chhattisgarh, Uttarachal and Jharkhand respectively. The President, Mr. K.R. Narayanan, gave his assent to all the 3 bills in late August. The states came into being in November 2000. Citizenship. Part 2 of the Constitution, Articles 5 to 11, contain provisions relating to citizenship of India. In brief, Article 5 states citizenship at the commencement of the Constitution. Article 6 states rights of citizenship of certain persons who have migrated to India from Pakistan. Article 7 talks about rights of citizenship of certain migrants to Pakistan. Article 8 states rights of citizenship of certain persons of Indian origin residing outside India. Article 9 states persons voluntarily acquiring citizenship of a foreign state not to be citizens. Article 10 states continuance of the rights of citizenship, and Article 11 talks about Parliament to regulate the right of citizenship by law. Single citizenship. The Indian Constitution, though federal, provides for single citizenship, namely the citizenship of India. There is no separate citizenship of a particular state from which a person may come. All citizens enjoy the same rights all over the country. Constitutional and statutory basis. The Constitution simply described the classes of persons who would be deemed to be citizens of India at the date of commencement of the Constitution and left the law of citizenship to be regulated by the law made by Parliament. Accordingly, the Citizenship Act of 1955 was enacted, providing elaborate provisions for acquisition and termination of citizenship subsequent to the commencement of Constitution. The Constitution entitled the following categories of persons to citizenship. 1. Persons born and domiciled in the territory of India. Domiciled persons include those with permanent homes in India, persons born in India whose father or mother was born in Indian territory, and persons ordinarily residing in India for at least 5 years before the commencement of the Constitution. Persons who had migrated to India from Pakistan, and Indians living in foreign countries at the date of commencement of the Constitution. Acquisition of citizenship. The various modes of acquisition of citizenship are prescribed by the Citizenship Act 1955. 1. By birth. Citizenship is conferred on those born in India on or after January 26, 1950, but before June 30, 1987, and those born on or after July 1, 1987, if either of his parents was a citizen of India at the time of his birth. The latter provision was added by an amendment to the Citizenship Act in 1986 in the wake of refugee influx from Bangladesh, Sri Lanka, etc. 2. By descent. A person born outside India on or after January 26, 1950 shall be a citizen of India if either of his parents is a citizen of India at the time of the person's birth. The above two categories are natural citizens. 3. By registration. A person can acquire citizenship by registering himself before the prescribed authority, provided he is of Indian origin and has been resident in India for 5 years, immediately before making an application, if he or she is married to an Indian citizen. 4. By naturalization. A foreigner can acquire citizenship on application for naturalization to the Government of India. A person acquiring citizenship by naturalization has to take an oath of allegiance to the Constitution of India. 5. By incorporation of territory. If any new territory becomes a part of India, the Government of India specifies the persons of that territory who shall be citizens of India. Termination. The Citizenship Act 1955 also lays down how the citizenship of India may be lost, whether it was acquired under the Act of 1955 or prior to it. It can be lost by 1. Renunciation. An Indian citizen who wishes to become a citizen of another country may voluntarily renounce his Indian citizenship. 2. Termination. Termination of Indian citizenship automatically takes place if a person voluntarily acquires citizenship of some other country. 3. Deprivation. This is a compulsory termination of citizenship of India by an order of the Government of India if it is satisfied that citizenship was obtained by fraud, false representation, or concealment of material facts, or if the person shows disloyalty to the Indian Constitution, or indulges in trade with an enemy country during war, or if the person has been sentenced to imprisonment for a period of 2 years or more within 5 years of his registration or naturalization, or if he has been residing abroad for 7 consecutive years. These methods of deprivation obviously apply to citizens by registration or naturalization. Significance of citizenship. It was only with the adoption of the Constitution on November 26, 1949, that the concept of Indian citizenship came into being. Before that, those who lived in British India were British subjects, and those from the princely states were British protected persons. Citizens enjoy full civil and political rights. A citizen enjoys all fundamental rights. He can vote in elections to Parliament and state legislatures and can contest for membership of these bodies. A citizen alone is eligible for appointment to certain offices such as those of President, Vice President, Judges of Supreme Court, High Court, etc. The citizen on his or her part has certain obligations to the state, like payment of taxes, defending the nation if required, etc. Though the civil and political rights are conferred equally on all citizens by the Constitution, irrespective of a person's birth or residence in any part of the country, permanent residence in a state may entitle advantages in some other matters. Employment under the Union is open to all citizens, irrespective of residence within any particular territory, but Parliament can lay down by law that in some classes of employment under a state or union territory, residence within that state or union territory is a necessary qualification. This condition is for efficiency, as knowledge of local conditions may be required for the job. In order to avoid any invidious discrimination at state level, it is provided that the Union legislature is the sole authority to legislate in this connection. For instance, by enacting the Public Employment Act in 1957, Parliament empowered the Union government to make rules for a specific period, prescribing a residential requirement only for appointment to non-gazetted posts in Andhra Pradesh, Himachal Pradesh, Manipur and Tripura. But this act expired in 1974, except in Andhra Pradesh, where, through presidential orders, people belonging to different parts of the state are provided equal opportunities in the matter of public employment and in the setting up of an administrative tribunal to adjudicate in the matter. A state is free to provide special benefits to its residents in matters that do not come in the ambit of rights given by the Constitution to the citizens of India. Thus, a state may offer concession in fees for education to its residents. In the case of Jammu and Kashmir, the state's legislature may confer special rights and privileges upon permanent residents of the state in matters of employment under the state government, settlement in the state, scholarships and other such forms of state aid, and acquisition of immovable property in the state. Fundamental rights, directive principles, and fundamental duties. Part 3 of the Constitution, Articles 12 to 35, deal with fundamental rights granted to individuals. These rights were finalized by a committee of the Constituent Assembly, headed by Sardar Vallabhbhai Patel. Nature of rights. These rights have not been defined in the Constitution, but it is agreed that they are described as fundamental because they are superior to ordinary laws. They can be altered only through constitutional amendment. Furthermore, they are vital for the full development of human personality, promoting an individual's dignity and welfare. These rights, unlike other justifiable rights, are protected by the constitutional remedy by way of an application direct to the Supreme Court under Article 32, which is itself included in Part 3. The fundamental rights are not absolute. They can be subject to certain restrictions. While some of these restrictions are spelled out by the Constitution, other restrictions may be imposed by the government. However, the reasonableness of such restrictions is to be decided upon by the courts. Thus, a balance is struck between individual liberty and social control. The fundamental rights can be suspended during emergency. Some of these rights are not available to the members of the armed forces. Some of the rights are available to all persons in the country, while others are available only to Indian citizens. The rights are available against the state and not against private parties. Article 12 defines state to include the government and Parliament of India, and the government and the legislature of each of the states, and all local or other authorities within the territory of India or under the control of Government of India. Article 13 prohibits the state from making any law taking away or abridging the rights in Part 3. However, This restriction does not apply to a constitutional amendment. Classification. Originally, the Constitution contained 7 groups of fundamental rights. But with the deletion of the right to property from the list by the 44th Amendment in 1978, there are now 6 categories of rights. These are: 1. Right to equality. Equality and liberty have been major ideals of many revolutions. The idea of equality, mentioned in the preamble, is elaborated and specified in Articles 14 to 18 of the Constitution. Article 14 provides, "The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India." Equality before law implies that no one is above law of the land. It is a corollary to the rules of law concept. Irrespective of rank or status, every person is subject to the ordinary law of the land. There is no distinction between officials and private citizens. However, exceptions are allowed by the Constitution to the President and Governor. The Indian Constitution allows the following exceptions to the rule of equality before law. 1. The President or the Governor of a state is not answerable to any court for the exercise and performance of powers and duty of office. 2. No criminal proceeding is to be instituted or continued against the President or a Governor in any court during his term of office. 3. No civil proceeding in which relief is claimed against the President or the Governor can be instituted during his term of office in any court in respect of any act done by him in his personal capacity, before or after he entered the office of President or Governor, until 2 months expire after notice in writing has been delivered to the President or Governor, stating the nature of the proceedings, cause of action, and other details. These immunities, however, do not put a bar on the impeachment proceedings against the President or on suits against the government. These constitutional exceptions apart, other exceptions, such as in favor of foreign rulers and ambassadors, also exist in accordance with international standards. Equal protection of the law has a more positive aspect to it than does equality before law. It means the right to equal treatment in similar circumstances, in the privileges conferred as well as in liabilities imposed by laws. None should be favored or placed in a position of disadvantage without a reasonable justification for such a different treatment. The legislature may enact suitable laws if a reasonable basis exists for different treatment. Thus, the law may exempt certain classes of property from taxation or impose differential tax rates on different trades. But within a particular class, the rates of benefit should be the same. In other words, every law need not have universal application, for people placed in different circumstances may have varying needs requiring separate treatment. As observed by the Supreme Court in one of its cases, a legislature which has to deal with diverse problems arising out of an infinite variety of human relations must, of necessity, have the power of making special laws to attain particular objects, and for that purpose it must have large powers of selection or classification of persons and things upon which such law are to operate. The classification has to be reasonable. It should be based on clear distinguishing criteria that set apart those grouped together from others, and those distinguishing criteria must have rational relation to the object that the law or act seeks to achieve. The basis of the classification may, for instance, be nature of trade or occupation, or it could be geographical, etc. To quote the constitutional authority, Dr. D. D. Basu, the guarantee of equal protection includes absence of any arbitrary discrimination by the laws themselves or in the matter of their administration. Thus, even where a statute itself is not discriminatory, but the public official entrusted with the duty of carrying it into operation applies it against an individual, not for the purpose of the act, but intentionally for the purpose of injuring him, the latter may have that executive act annulled by the court on ground of contravention of the guarantee of equal protection. Of course, it is for the aggrieved individual to establish beyond doubt that the law was applied against him by the public authority with an evil eye and an unequal hand. In short, Article 14 hits arbitrariness of state action in any form. Article 15, available only to citizens, prohibits discrimination by the state on grounds of religion, race, caste, sex, or place of birth. On the same grounds, no citizen will be discriminated against in regard to access to shops, public restaurants, hotels, places of public entertainment, and use of wells, tanks, roads, etc., maintained out of state funds, or dedicated to general public use. However, this does not prevent the state from making any special provision for women or children, or for the advancement of any socially and educationally backward classes or citizens, or for scheduled castes and tribes. Article 16 assures the citizen of equality of opportunity in matters relating to employment or appointment to any office under the state, irrespective of religion, race, caste, sex, descent, place of birth. However, Parliament may make laws prescribing residence within a state as qualification for certain categories of posts under any state or local authority. The state may also make reservation of appointments for any backward class of citizens not adequately represented in the services under that state. Offices connected with a religious or denominated institution may be reserved for members of that particular religion or denomination. The claims of the SC/ST shall be considered in the matter of appointment to services and posts under the Union and States, as far as may be consistent with the maintenance of efficiency of administration. Article 335. Article 17 abolishes the practice of untouchability. Parliament is authorized to make a law prescribing punishment for the offence of enforcing any disability arising out of untouchability. Accordingly, the Untouchability Offences Act 1955 was enacted, later amended and renamed in 1976 as the Protection of Civil Rights Act 1955. We will continue the topic of fundamental rights in the next section.